There has been much attention on this case. Members have filed questions, many news reports and commentaries on this since September. There has been interest because underlying these questions, which are specific to the case, there is a broader, more fundamental question. Did a powerful man, Mr. Liew Mun Leong, and I'll refer to him as LML, work the system to his advantage? Did the police and AGC unfairly prosecute Ms. Liyani because LML was a complainant? Did Ms. Liyani get a fair trial in the state courts? Do we have one law for the wealthy, socially connected, and another for the rest of society? This fundamental issue is at the heart of many of the questions that have been raised. And that question is of central importance to us. The credibility of our system, the foundation of our society, depends on us ensuring that there is rule of law and the law applies equally to all. If that principle is compromised, then Singapore is compromised. It is a basic duty of the government to ensure that that principle is upheld, and I take it very seriously. The facts are as follows. Ms. Liyani was an Indonesian domestic worker working in Singapore since 1997. According to her, LML was her third employer, but MOM records show that LML was in fact her seventh employer. She worked for LML from March of 2007 until 28th of October 2016. Her employment was terminated on that day. In court, the following was said, and I'm setting out what was said, not commenting on whether it is true or false. Over the years, the family's possessions went missing. LML gave examples such as a bag he bought from Tokyo, his jogging shoes, a number of Longchamp bags. He suspected Ms. Liyani of stealing, but did not take action as he could not be sure. A specially designed power bank from France that was gifted to LML disappeared a few days after he received it. Subsequent investigations show that this may have happened in May of 2016. By then, the only occupants in the house were LML, his wife Ng Lai Peng, whom I will refer to as NLP, and Ms. Liyani. Though some others may have had access to the house, LML then decided to terminate Ms. Liyani's employment. In this context, and I should add, and I will come back to this later, subsequent investigations also show that earlier in late 2015, the Liews were looking to replace Ms. Liyani because they thought she was stealing things, but no firm decision was taken. In September 2016, they decided to terminate her employment and told the maid agency. Once a replacement helper was available, they decided to let Ms. Liyani go. LML was traveling. He told his wife to arrange for people to be around and serve the notice of termination. On the 28th of October 2016, at about 11 a.m., Carl Liew, I'll refer to him as Carl, LML's son, went to LML's residence at 49 CL with employment agents, and this was at LML's request. Carl told Ms. Liyani they were sending her back. No reasons were initially given. Ms. Liyani asked for reasons. Carl told her that there are missing items in the house, and the only people staying in the house were my father, my mother, and you. She was asked to pack her belongings and given 2 months' salary as compensation in addition to that month's salary. Ms. Liyani asked for boxes to pack her things. These were provided to her. She packed them with some assistance from the Liews' other employees. She sealed one box with tape and wrote her address on it. The other 2 boxes were sealed by 2 other employees of LML. Carl agreed to pay for the boxes to be sent back to Indonesia. Ms. Liyani left the house with the employment agent and returned to Indonesia that night. The replacement helper commenced employment at LML's house on the same day, 28th of October 2016. When he got home, Carl told his wife, Heather Lim, and I'll refer to her as Heather, about what had happened. Heather told him that the boxes should not be sent back without knowing what was inside them. On the 29th of October 2016 in the afternoon, NLP, Carl, and Heather opened the boxes. They said they found items which belonged to them, which they had not seen for years. They spent about 2 hours going through the items. They also took a 21-second video. LML returned to Singapore sometime on 29 October 2016. He spent a short time going through the contents of the boxes. And on the 30th of October 2016, at 3:54 p.m., LML lodged a police report at Tanglin Police Station. On the 4th of November 2016, a police gazette was issued. I will come back to this later and deal with the police gazette. On the 2nd of December 2016, at about 9 p.m., Ms. Liani returned to Singapore. She was arrested at the airport based on the PG. Ms. Liani said in her statement to the police that she came back to visit a friend and go sightseeing thereafter, and she planned to return to Indonesia before going to Hong Kong to work. Later in court, she said that she in fact returned to Singapore to look for her agent and seek employment. When she was arrested, some items were found on her. These are listed in Annex 1, Table A to my statement, which will be distributed later. There is only one annex before members. That's a different annex. The others are outside. I think in the interest of time, we won't distribute each annex as I go through. The Liews said these were also stolen items. These items were seized and subsequently included in the charges against her. I will now deal with how the investigations were conducted by the police, how AGC assessed the case, and proceeded. LML had lodged a police report, as I said earlier, on the 30th of October. The police report stated that over the years, the family's belongings had gone missing. They suspected Ms. Liani. They terminated her employment on the 28th of October, and they found some of the items packed in her boxes. LML's statement was then taken. Initial investigation showed that Ms. Liani had left Singapore on the 28th of October itself. LML had set out in his police statement the items which he said had been stolen. The items were, according to LML, found amongst Ms. Liani's belongings in the boxes. Theft is an arrestable offense. Police needed to trace Ms. Liani to investigate further. Where there is reason to suspect that an arrestable offense has been committed, police will try to find the alleged offender and, if appropriate, arrest the person. If the person is at a known address, the police can go and interview the person. If there is no known address, or if the person is believed to have gone overseas, then a PG will be issued. And so a PG was issued in this case. Ms. Liani was believed to have gone overseas. On the 2nd of December, at about 9 p.m., as I said earlier, she was arrested at the airport. On the 3rd of December, police went to Liew's houses. They first went to Carl's house. One of the 3 boxes had been moved there. Carl told the police the items in the box were his. Police were told that the box containing Carl's items had been brought back to his home. The box contained an assortment of items: clothing, bedding, kitchenware, utensils. Items were taken out, laid out, photographed. These photos were used in recording the various statements taken subsequently. The physical items were not seized. Police then visited LML's house. Police were told that the 2 boxes had remained there. NLP recovered some items from the boxes: jewelry, accessories, watches, Gucci sunglasses. Police seized 51 items. 21 items eventually formed the 3rd charge. They were said to belong to LML's daughter, Ms. May Liew, and I'll refer to her as May. And these items are set out at Annex 2. Police did not seize all the items. They were seen as daily use items. The Liews claimed these items. Photographs were taken in lieu of seizure. Items found in those boxes are set out in Annex 1, Table B. Police then continued their investigations. They took statements from Ms. Liani, the Liews, and other witnesses. The matter was then referred to AGC. I will now set out how AGC proceeded in coming to the charging decision. When AGC receives a file from a law enforcement agency, the prosecutors will assess whether a charge is appropriate and what action, if any, should be taken. The assessment and decision are usually cleared by a director. Files are typically cleared at the director level, not usually brought up to a higher management, by which I mean the Deputy Chief prosecutor, the chief prosecutor, deputy attorney general, or attorney general, unless they involve more serious or sensitive crimes or where the AG's consent to prosecute is expressly required. Ms. Liani's case was no different. It went through the same routine and the charging decision was cleared at the director level. The events leading up to the charging decision were as follows. On the 5th of June 2017, police sent the file to AGC with their investigation findings and recommendations. Such theft files are routine matters handled by AGC. Over the last 3 years, AGC has dealt with an average of about 3,000 reports every year for theft in dwelling and theft as servant offenses. The file was reviewed by 2 DPPs. They asked the police to investigate a number of further points. The police did that and returned the file to AGC with further findings. DPPs then reviewed the file, they sought further clarifications, and the file was then sent back to police for further investigations. Police conducted further investigations, then they sent the file back to AGC. DPPs reviewed the evidence again. This back and forth between police and AGC is again normal. In many cases, DPPs will look at the material and ask further questions. And because of the system in AGC, depending on which officer is on duty, it would be different DPPs who look at the same file. And that's what happened here as well. From the police and AGC perspective, this was handled as a routine theft case. There was no attempt by anyone to influence them. Police report was filed and the matter was dealt with as such reports are usually dealt with. I will come back to this. AGC decided to charge Ms. Liani the 2 main reasons. There was sufficient evidence which showed that theft offenses were likely to have been committed. And second, it was in the public interest to prosecute. And let me explain this. The evidence before the AGC at the time was as follows. The Liews had identified all the items in the charges as items belonging to them and gave some detail. In contrast, based on what AGC saw, Ms. Liani gave answers which raised many questions. I will highlight some of these. Ms. Liani claimed that she had found some jewelry in May's trash. May stated that she never threw jewelry away. She would give unwanted jewelry to Salvation Army or friends. AGC's assessment was that the evidence of May was more believable. Ms. Liani also claimed that she had found items such as a Prada bag, 2 Apple iPhones, a pair of Gucci sunglasses in the trash. AGC did not find this to be credible. The list of items that Ms. Liani said she found in the trash are at NX3, and those are the photographs that have been circulated to members. Ms. Liani also expressly admitted to taking some items, 10 to 15 items of clothing, and let me explain this. In her first statement dated 3rd of December 2016, Ms. Liani was asked how she came into possession of male clothing. She said the clothing belonged to her employer. She said she took the clothing because the clothes were small. She assumed her employer's son, Carl, would not want the clothes. She did not ask Carl whether she could take the clothes. She admitted to taking the pieces of male clothing in early 2015. In her second statement, dated 4th of December 2016, Ms. Liani said, I only took about 10 to 15 pieces of men's clothing belonging to my employer's husband. I admit that I took it without informing my employer or her husband. And she also said, I only admit to taking the 10 to 15 men's clothing belonging to my employer's husband without consent, and I did not steal any other items. Her statement that she did not steal any other items is also very significant. Prima facie on the statements, this would appear to be theft. AGC assessed the case based on this and other material. I should add that under cross-examination in court, Ms. Liani said she was only given permission to take these items if Carl did not want them, but she did not ask Carl, meaning she just took the items. Ms. Liani also gave contradictory accounts to the police on several other items. These inconsistencies are set out in Annex 4. I will highlight 2 instances of inconsistencies as illustrations. A Vacheron Constantin watch and a Swatch watch. In her statement dated 4th of December, Ms. Liani said these watches were gifts from a friend. However, in a later statement of 29 May 2017, She said she found these watches in May's trash. A pair of Gucci sunglasses. In her statement dated 4th of December 2016, she said this was a gift from LML's previous helper. In a later statement of May 2017, she said she found it in her room at LML's home when she first started working for LML. I should add, later in court, Ms. Liyani was asked about these contradictions. She gave explanations. Her explanations are also set out in the table at Annex 4. Putting together Ms. Liyani's apparent inconsistencies, her answers on the jewelry and the other items, which she said she found in the trash, like the Prada bag, the 2 Apple iPhones, a pair of Gucci sunglasses, her other questionable answers, her admission to taking some male clothing without permission, AGC's view was that there was a case to prosecute. At that stage, the Liew's position was that the items were theirs. AGC also took the view that there was a clear public interest in prosecuting Ms. Liyani. 2 reasons. One, it appeared that Ms. Liyani had stolen many items, including some seemingly expensive items. And 2, it appeared that she had been stealing for years, and it was not impulsive, spur-of-the-moment decision. So the question for members in this House, in this case, is, on what I have set out, what material evidence did police and AGC have? What does that show? Was there a basis for AGC's view that the case ought to be prosecuted? That is why I have set out this material in some detail so that members can assess for themselves the basis for the decisions that police and AGC came to. I'll now move on to the trial. The trial was heard in the state courts over 20 days, from the 23rd of April 2018 to 17th of January 2019. The DPPs who conducted the trial were different from the DPPs who had previously been involved in the charging process. Ms. Liyani was represented by counsel assigned under the Criminal Legal Aid Scheme, or CLAS, for both the trial and the appeal. I will come back later to CLAS. Let me now turn to the state court judgment. The trial judge found serious inconsistencies in Ms. Liyani's evidence between what she said in court and her previous statements. The state court noted that Ms. Liyani had various versions in relation to specific items. Ms. Liyani said different things in her statement compared with what she said in evidence in chief in court, and then sometimes changed her version under cross-examination. I've earlier referred to Annex 4, which sets out these inconsistencies, and also her explanations for these inconsistencies. The state court found Ms. Liyani's evidence on some items to be implausible. For example, the 2 old white iPhones. She said she picked up the 2 phones from a rubbish bag. These were iPhone 4 models, probably about 6 years old as of 2016. The state court preferred the Liew's evidence that they would not discard old mobile phones as they were used as spare phones or as hard drives to keep photographs. Jewelry, Ms. Liyani said that most of the jewelry was picked from May's rubbish in 2011 or 2012, and she did not seek permission to take them. May identified the items as hers and provided circumstances of how and why she purchased them. The state court preferred May's version as it was more detailed and she came across as honest and forthright. Ms. Liyani said a purple Prada bag and Gucci sunglasses with red stains were found in a rubbish bag. The state court accepted Heather's evidence that these items were never discarded. The trial judge said the modus operandi of Ms. Liyani was to take variety of items from different family members, thinking that this would go unnoticed.